Good one. Maybe then. Criminal appeal prayer for listing your listing due to the court master. We are not assuring you dates.
May I please, Your Lordship? Your Lordship, I have a similar prayer for listing of the criminal appeal.
Due to the court master, we are not assuring.
Much obliged, Your Lordship.
Daily list, item 1 for admission.
Yes.
Item 1, Lordship, I have the guidance Lordship income tax regarding husband. That I could not come back to Lordship. Some more time will be required.
How much time, Mr. Shah?
Regard this against the maintenance amount given in.
Okay. Mrs. R. Chaudhary, counsel for the appellant. Praise for it is granted. How much time? 2 weeks for the time to file affidavit as ordered by, as per order dated 13/3/2024. List after 2 weeks.
Item 2,
It's come for the first time. Appeal. Mrs. R. Chaudhary. Under which section? Offense 302. Okay. Steps by usual process as well as by registered post with AD, which shall be processed and routed through the jurisdictional magistrate. Notice may give a date after 5 weeks. That will be considered on receipt of LCR, IA. Objection, if any, by the state, by then.
April, 30 April.
Obliged.
Item 3,
It's come for the first time. Offense is under which section?
302, madam.
302. Same order. Mr. K. Barua, counsel for the appellant. Same date. Take steps.
I also.
I also.
3004.
LCR. Consider. Yes, item 4.
Your Lordship, I submit the date was passed over the matter of timely.
It's come for the first time. Officer of which section?
Also, Lordship.
OXO.
676.
So will be through APB. Your name? M. Garg.
Bharali, BHARALI.
Bharali. And M. Bharali. You also record her presence. Ms. N. Das, APP. Okay, take steps within both ways. One through APP.
item 5,
Live streaming. Live streaming. Yes, you're not taken steps. To take steps.
তারপর
Hmm?
LCR also not বেশি।
Participant has taken steps on 19/3/2024.
19-3.
Steps have been taken, my lord.
19-3. That's not on record. Okay.
Office not taken.
Okay. Mr. B. Barwa, counsel for the appellant, submits that on 19/3/2024, usual process was taken for service of notice on respondent number 2. First of the registration shall track the steps and issue notice on respondent number 2 by usual process, which is made returnable on 29/4/2024. First of- The process should be routed through the jurisdictional magistrate. That's why in the event registry is unable to track out the steps, comma, you would inform the counsel for the appellant through the email address provided for taking fresh steps. Next one, list on 29/4/2024.
But CR is also not received.
Okay, reminder for LCR. Registry says issue the reminder for LCR.
Item 12,
The office is under which section?
302.
302.
Well, last I, it said it's condemnation, really condemnation. There is this delay, and
Delay of 25 days. We are convicted under which section?
6 of October.
POXO. So notice has to be sent. Uh, But Mr. I Hassan, counsel for the applicant, issue notice on this application under section 5 of the Limitation Act for continuing the delay of 25 days beyond the period of limitation in filing the connected appeal against judgment and order dated judgment dated 29/11, order dated 30/11, page 1. Huh? Ms. Andas, APP accepts notice on behalf of respondent number 1. First up, next para, in terms of notification number 17 dated so and so, the applicant shall take steps for service of notice on respondent number 2 by registered post with AD. First up, moreover, comma, an additional step shall be filed which shall be processed by the registry and handed over to the Office of the Public Prosecutor Assam in Guwahati High Court for service on respondent number 2 through the officer in charge, Majuli Police Station. Post- The officer in charge of Majuli Police Station shall ensure that the service report is written prior to the next date of listing. List on 29/4.
Okay.
Item 13.
There is a day of 3 days.
What, you are convicted under which section? Also, then notice has to be sent. Mr. A. Barwa, counsel for the applicant. Same order. This is, police station is Bokajan. See from the judgment. Judgment first paragraph you will find.
14. Page 14.
Huh?
Page 14, Lordship.
I am not hearing you.
Page 14, Lordship. of
No, no,
FIR.
just tell us the police station. Aurangabad PS. In first paragraph, it will be saying,
Lordship.
in the first paragraph of the judgment, it will say which police station case.
Bokajan. Bokajan.
Bokajan PS. Same order. Steps 29/4.
Item 14.
3 days delay. 69 days. What is the offense? 302. Ms. Das, if it is 302, we strike out number 2, otherwise it unnecessary that there are delays. It's not required. We'll delete that. No, no, you say no, no. They can come. No, if they want, and without giving them a notice, how will they know?
That is what's confusing, but they somehow have to take up and then get it.
No, then you see notice is required. Because if in the no, in the bench, you see, my opinion would be that if somebody is a party, notice has to be sent. He does not appear is his or her choice. But when there is a party on record and I don't issue notice, that would be judicial impropriety, I think.
They can come later.
They can come in later. We'll give that liberty in the order and then just
Yes, the council. And just bring first of all. They have done
Yes.
so they can-
she's a legal aid counsel, so therefore we will put words in her mouth. We'll record your prayer of striking out number 2 with that liberty. At the outset, Ms. LDV learned counsel for the Legal Aid Council submits that in view of notification number 17 dated so and so, the respondent to is not a necessary party as the appellant has been convicted of committing offense punishable under section 302 IPC. Full stop. On the said prayer, Ms. Ann Das, Learned Counsel for the Learned APP, submits that this court may grant liberty to the respondent to to appear. If the, if so desired, so according to prayer is allowed, the name of respondent two is struck off. As the interest of the respondent two shall be otherwise taken care of by the learned APP. Next part. This 69 days, we give you a notice. We'll take it up next week.
Sure.
Issue notice on this application under section 5 of the Limitation Act, by which the applicant is paid for continuing the delay of 69 days beyond the period of limitation if the connected appeal. Issue notice returnable in a week. First of objection made by the state be filed within that time. Next, list after a week.
Item 15.
Yes, Ms. Kapasari.
Okay, there is a delay of 97 days.
97 days. What is the offense?
302.
302.
I have received the papers on the first of.
It's okay. We are giving a week's notice. If they want to object, they will do it. Heard Ms. D. Puchari, the Legal Aid Council, same order, limitation 97 days. Ms. And thus, the review accepts notice on behalf of the respondent. Objection, if any, by the next date, list after a week.
Supplementary item 20 for orders.
File my objection. What my learned friend is saying.
Perhaps you are secretive when filing.
Lordship, I did not check if I had.
No,
I hope my
it's
objection
not
is clear.
available.
Not available.
Not available.
Oh, then something has happened with me.
Then you'll have to, then you'll change your language to, I had given to my clerk to file it.
I have given it to my clerk. Something has
Correct.
happened.
Okay.
I was under the impression this file is in the records. Lordship will give me 3 days time. By Wednesday, I'll file it.
Okay. Service is complete.
When-
So Ayush Chaudhary, counsel for the appellant, appellant is present. First off. Ms. S. Jahl and APP praised for and is granted 3 days time to file opposition to the interlocutory application. Next paragraph, office note dated 21/3/2024 indicates that notice was duly served on the respondent number 2.
Oh,
Mr. Howard, none appears on call for the respondent number 2. This is offense 302. Okay. List on 1/4/2024. Mr. Chaudhary, you are fixing on 1/4.
Item 21.
I've served the lordship. I was supposed to get the instruction whether it is served. The notices are served. I've given a mail. Isa? Yes, Mohuruddin, Chaigaon, lordship will see. This is served.
This is POXO.
Also.
So we appoint an amicus curiae and proceed with the matter.
Yes, lordship.
Okay.
It was served on Mayur.
Then you can appoint you as AP, legal counsel in the matter.
Lordship, Ms. Devi.
Ah.
Yes.
Earlier, I was in the panel, let's say.
Legal.
Okay.
Gitanjali.
Suggest a name?
Lovely
Yes.
is
Ah,
there.
yes. Yes, they will appoint you as legal aid counsel in this matter. Okay. Mr. Ayush Chaudhary, counsel for the appellant is present. Ms. S. Jahan and the APP has produced a communication from the officer in charge of Chaigaon Police Station indicating that notice was served on the respondent number 2. The report dated 21/3/24. This was served on so and so. As none appears in call for the respondent number 2, having noticed that the appellant was convicted for committing offense punishable under Section 4 of the POXO Act, court is inclined to appoint Ms. L. Devi Leonard, legal aid counsel, to represent the interest of respondent number 2. The current counsel for the appellant shall provide a copy of the memo of appeal and this interrogatory and the connected interrogatory application to the London Legal Aid Council. Next one. Court permits the Learned Legal Aid Council for respondent number 2 to address the court on objection, if any, to the interlocutory application. If for some reason the objection, formal objection cannot be filed, you will not get instructions. When? You will give it by 2 days?
Next week, there are only 2 days. So. 2nd of April or whatever, after vacation. 4th, she's saying. 4th of April. And not 4th.
Not 4th, we'll make it 5th, 5th of April.
Gotcha.
Give me copies. The photocopy of sorry, the scan copy, the photocopies of the communication by the officer in charge of Bagribari, oh, sorry, yeah, this is,
Saigon.
no, this is not Chaigaon, this is, don't make it Chaigaon, this is
Acha.
Jorshi, JORSHIMULI, outpost. What is this designation within bracket P?
Hidden back. FR concern?
What is this designation of this man?
Oh, acha.
Some,
The one who had given a notice.
you say in charge, so and so outpost. Jorshi Muli, outpost,
what was
district
it?
Kamrup.
Joshimili outpost, in charge. It will give a E to Narana. In charge to Vulgalize.
In bracket it is P.
XP.
SP will not write as in charge outpost.
P is within bracket.
Outpost will not have
Four,
a,
I think it's four. Oh, no, A Mantu is a decision. I think that before the letter before the P is, I think for four. Summer duty.
no, 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 no.
It is
P
bracket only.
indicates, P is, he is giving his designation.
SIP probably lot.
SIP মানে কি?
No, no, after P also there is this is a bracket.
There's a bracket. I have no.
It's just right, only in charge, so and so outpost, so and so is, and the, sorry, is made a part of record.
So he is appearing for the response.
Oh, you are appearing.
Oh,
Okay, okay. Thank you, but still.
Mayurjan. Oh. huh? Oh, yes. He is appearing.
Just. Then instead of, you write his name.
What do we?
Uh, Mr. F.A. Hassan, London Council enters appearance for the respondent to copies of the memo appeal and the interrogatory application be filed, will be supplied to him within course of the day. Objection, if any, within, objection,
Yes, ma'am.
you want to file? Objection within,
2 weeks.
the objection, any within 10/4.
Ninth of April.
Within 8/4, okay,
Not you.
you file it within 8th of April, correct?
But 10th of April, we may not
No,
be, I may not be here.
we're putting it after that vacation,
Acha,
list on 19/4/2024.
acha. My objection is already on record.
Your objection in IA. It is there. Just say objection by the state in the interlocutory application is available on record. List on 19/4/2024. Yes, Mr. Mahmood, your matter 22,
That is also served. I have served it through the police officer.
that Bagri Bari.
Bagribari.
Oh, it is there.
Lordship can see the service report.
Yes.
To Deben Burma or legally to Divasai. Officer in charge of
Sorry.
Bhakti. Lovely
So-
Devi can be.
Ah, in this case, we are appointing you instead of that. Um, Mr. M. U. Mahmood, counsel for the, learned counsel for the appellant dash applicant. Ms. S. Jahan under APP has produced a copy of communication received from the officer in charge, Bagribari, B-A-G-R-I, Bagribari Police Station, stating that notice was served on respond number 2. First one. Non-appearance on call for the respond number 2. Next paragraph. Having seen that the appellant was convicted for committing offense
Just 39 of the criminal offence.
under section 6 of the POCSO Act, the court is inclined to appoint Ms. L. Devi, learned legal aid counsel, to represent the interest of respond number 2. Full stop. Let a copy of the memo of appeal and the connected interlocutory application be served on her in course of the day. Next paragraph. The court permits the learned legal aid counsel to address the court on her objections in the interlocutory application if objection cannot be filed. Yes, your objection?
As a file now.
Right. Again, something secretive.
File it long back. I've given him a copy as well. File it on 22.
It's not available.
Oh, it was
Communication,
earlier, oh, acha, it is an
communication-
earlier rejection petition.
communication, received from the
Oh.
officer in charge, Bagribari Police Station, kept as a part of the record. আগতে করে দিব, হ্যাঁ? Yes,
He had filed a fresh application. I had filed it in the earlier application. Same person, he has filed it for the second time.
so,
I'll file it afresh then in this.
oh, okay. The objection by the state also shall be filed within same date, 8th of April, list on 19th April.
Didn't it?
We have already passed orders. I'm passing a single order, common order in both the cases together.
Gotcha.
Daily list item 16 for hearing.
Yes, some personally.
No, one thing is that, the report had not come. And the spermatozoa which was found in the undergarments of the victim were sent for FSL. That, the matter relates to quite a few years back. So it is, the matter is from Nagaon. So the police have sent those articles to the FSL for examination, but that examination report is awaited. It has not come back.
Initial order was passed by this court on 6/6/2023. Yeah.
Then we'll ask the superintendent of police to make inquiry as to why,
Hmm.
despite the order,
Lordship can see there is a annexure K there, where it is said, the district and session judge has given a report to the High Court saying that police have sent the articles to the FSL, to the exhibits.
Perhaps it is 9th of January.
It is flag marked as K.
uh,
From Nagaon, the exhibits are sent to Guwahati FSL, but they have not given us the report. And it's long time.
just
Dada.
just give the LCR.
LCR.
Yeah.
Sample exam. 120. Exhibits, Lordship can find it in the paper book itself. There are two exhibits.
Just a
which-
moment.
Yeah, Lordship.
This order says there was a positive test.
Yes. There was a-
Positive test means
That presence of. spermatozoa-
it was positive.
It was positive. There were two exhibits. Exhibit 3627G and 3627I, which had given positive test for spermatozoa in the undergarments of the victim, but it was not tested with the accused.
But now it can't be done. What has lapsed? The test will never materialize.
Because blood samples to be taken from the accused and it was supposed to be matched. Another examination.
No, you see this sending for FSL, as per the case diary available here, steps was taken as per entry made on 27/12/2015.
Hmm.
So
Yes, things
So
will not be in a proper state, even if it is there. It is there, and in the judgment, it is reflected that things should be destroyed. But then it is there. Lordship had directed, my Lord Justice Michael Jotankuma had directed to find out whether those articles were there in the Malkhana or wherever it is kept.
no FSL would retain a sample after they have given a report.
So
And even
this
if-
was sent from the Malkhana again to the FSL
When?
after this Lordship's order.
January communication letter
January.
from the learned court below.
Police have sent it from their Malkhana to the FSL.
Okay.
Lordship,
Uh,
so many time has elapsed.
Yes, yes.
we'll pass an
Quite
appropriate
some
order.
time has elapsed.
Now he will come, don't worry. Which police station?
Samoguri.
Samaguri.
itu 16 চলি আছে এটা 17 এই
ক্ষমা করুন।
18 এই আরে এই কি হলো?
Otherwise, in the, as far as the merit of the case is concerned, the evidences were lacking. It's a small girl being raped and murdered. 4.5 year, no? 6.5 year old.
Lordship, there is appraisal judgment, Lordship, for this lacuna from the prosecution side, Lordship. It is a case of acquittal, Lordship.
No, it's okay, but still we'll have to, when there's a judicial order, we'll have to bring it to logical conclusion. What is this envelope? From Director Forensic Science, from you to Director Forensic Science, what is this?
I had sent a letter. Initially, I had sent letter to the FSL, they did not respond. So I made a prayer that registry to do it, and then Lordship had directed a registry. And it was kept on record.
Okay. The Ms. A. Devi Leonard, Legal Aid Counsel for the appellant, and Mrs. Jahan Leonard, APP, are present. Next paragraph. It is noted that pursuant to order dated 21/11/2023 passed by this court, the district and sessions, the learned session judge, Nagaon, has sent a communication to the court. The communication dated 12/1/2024 to the court. To inform that the exhibit numbers SERO, this will you'll find in bracket A. Huh? Were sent to the Forensic Science Laboratory, Kahilipara, and that the report is awaited from the concerned department. Post. It is Has the routing of communication from this court to the Director of Forensic Science Laboratory through the Court of Special Judge, oblique Sessions, Special Judge and oblique or Sessions Judge Nagaon is likely to consume time, comma, the court is inclined to issue a notice on the Director of Forensic Science Laboratory, comma, Kailipara, Assam, to positively inform the court prior to the next date of listing on the report, comma, if any, on the exhibits referred above. Next para. The learned ABP shall transmit a order of this court to the VHF unit
DFS.
or we have a VHF unit, to VHF unit or to any other mode of communication like email, etc. by sending a downloaded copy of this order to the Director, Forensic Science Laboratory, Kailipara, Assam. Assam Kailipara. Post of the said authority shall ensure that report is communicated to the court prior to the next date of listing. List on 8/4/2024. You just add there, Sarvas so and so, in connection with Samaguri PS case number 472 of 2015. Permitting to send a downloaded copy of the order.
I'll send it. Last time I had sent all the orders along with a letter to the office through my office person.
No, that's
They
okay.
did not they refused to even accept it. So I made up.
No, that's okay. They may have their own way of working. So that's why we are passing a judicial order.
I'll send.
Applause.
Item 17 for hearing.
Lordship, before my learned senior colleague starts, Lordship, there is a fresh proposal of mutual settlement from the side of the husband, Lordship. I need to take instruction on date, Lordship. Because
Happy a lot. So in this case, Lordship, Ahmed will appear in coming Lordship. If Lordship allow me to argue this case, Lordship, then I will start Lordship. Lordship, in this case, Lordship, the appellant, Lordship, initially, Lordship, the case was registered, Lordship, under section 376 of IPC, read with 4 of POCSO Act, Lordship. And charge sheet was submitted under section 326, read with 4, and charge was framed under 376. 3, read with 4 of POCSO Act, Lordship. And after conclusion of trial, Lordship, the appellant convicted under section, Lordship, 376(3), read with 4 of POCSO Act for RI for 20 years, Lordship. Lordship, FIR will find, Lordship, page 4, Lordship. The informant is the father of the victim, Lordship. Page 4, Lordship, FIR. May I read, Lordship? I have the honor to state that around 5 p.m. today, that is on 5/1/2020, when my daughter, Miss Narjina Begum, aged about 15 years. As per medical report, Lordship, her age was 15 to 17 years, Lordship. Went to the nearby field to bring the cattle back. The aforementioned accused, who was waiting near his home, took the advantage of the absence of other person there at that time, grabbed my daughter and gagged her. Thereafter, the accused removed my daughter's clothes and took her photographs with his mobile phone. The accused threatened her that if she told about it to other persons, he would send the photos to the mobile phones to other people to defame her. Thereafter, the accused committed rape on her. Later, my daughter came home crying and narrated the incident to us. Therefore, I prayed to you to take necessary action against the accused person. Lordship. The FIR was filed on, Lordship, 5/1/2020, Lordship. On the same day, Lordship. And Lordship, PW1, Lordship, the father of the victim, Lordship, informant, Lordship. PW1, Lordship, page 8, Lordship. May I read, Lordship? I am the informant in this case. Exhibit P1, PW1 is the first information lodged by me, where on Exhibit P1 is my signature. Exhibit P2 is another document seen in the case record on which PW1 is my signature. I have instituted this case against the accused Nuru Sikdar. I know him and he lives near my residence. My daughter Nazira Begum is victim in this case. The incident leading to this case had taken place around 2 years back at around 5 p.m. to 5:30 p.m. half a kilometer away from my residence in a field at that time being used as grazing field. At the relevant time, I was in the market of our village. When I came back to my residence from market, it was getting dark in the evening. My daughter was already there and was crying. Then I asked him the reason for her crying. He told me that she had gone to the place of occurrence field to bring the cow belonging to us back. When the accused Nuru Sikdar had gagged her mouth with the help of a cloth, he dragged her to a bush there and then had committed penetrative sexual assault on her. Then I immediately took my daughter to Basugao police station. The police recorded my statement and that of my daughter. Then someone drafted the first information and I put my signature thereon. Then the victim was immediately brought to Kajolgaon Civil Hospital, but in absence of doctor, her medical examination could not be done. I had accompanied her, then she was taken back to the Basugao police station. Then I took her to my residence. After a gap of 1 day, the victim was again brought to the Kajolgaon Civil Hospital. After 1 day, Lordship, she was medically examined, Lordship, and her medical examination was done. Those with the victim, I am unable to recall if my signature was taken on any paper in the hospital. I have seen document in the case record marked as Exhibit P3, where on Exhibit P31 is my signature. I do not remember why my signature was taken there. The police had seized birth certificate of my victim daughter from me. My signature was taken on a paper after that. Exhibit P4 is a document seen in the case record whereon Exhibit P4 is my signature. Srimati Rasminara Khatun, wife of Rabiul Hussain, who is my neighbor, had gone with me to the police station when the certificate was seized. Material Exhibit 1 is the birth certificate of my daughter, which was seized by P4. Her date of birth is 12/1/2005. The name of victim's younger sister is Asmina Khatun. She was born in the year 2009. Accused Nur Sikdar is present in the dock of the court today, cross, Lordship. I do not remember the date on which this case was instituted. Exhibit P1 was scribed by someone at the police station. I do not know what is written in the said exhibit. After I had taken the victim to police station for the first time, the police had recorded my statement. I have taken my daughter to the police station at around 7 p.m. At that time, my statement was recorded. At around 10 p.m. to 10:30 p.m., she was brought to Kajolgaon Civil Hospital. Then we were back to the Basugao police station at around 11:30 to 12 at night. 12 at night. I had not noted the time when I was back to my residence after that. About 2-3 days in the afternoon,
2 weeks.
around 2:30 p.m. to 3 p.m., the police said to come our residence. I had earlier instituted a case against accused and his brother. The said case was resulted in his acquittal after compromise, Lordship. Initially, Lordship, they filed another case, and in that case, Lordship, we were acquitted, Lordship. At the time of incident, my daughter was about 14 years of age. But in the FIR, Lordship, he stated that the victim girl is about 15 years, Lordship. But in the cross, Lordship, at the time of incident, my daughter was about 14 years of age. My eldest daughter, Shahida Begum, lives in the village Tilapara outside the district of Chirang. My victim daughter present has gone to her house. It is not a fact that I have given my victim daughter in marriage to Quran Ali, son of Isam Ali also. It is not a fact that I have instituted this case with false allegations against the accused in view of the already existing grudge because of old dispute with him, and also because in this earlier case instituted by me, he got acquitted. He has got acquitted. It is not a fact that no incident as alleged by me had taken place against my daughter. I do not know what is written in the seizure list. I put my signature as I was asked to do so. Now, Lordship, PW2, Lordship, she is a victim, Lordship. Page 12, Lordship, next page, Lordship. My father is the informant in this case. When he had lost this case, I had accompanied with him to the police station. This case has been lodged against accused Nuru Sikdar. He belongs to our village. His residence is at 10 minutes walk from my residence. The incident leading to this case had taken place in the month of January 2020 at around 5:30 p.m. to 6 p.m. in a field near the house of the accused. At that time, I was studying in class 9 in Urboshi Brahma Memorial Girls High School at Kashikotra. I had gone there to bring back my cows, which were left there for grazing. With me, my younger sister Asmina Hatun, he had also
Learned Counsel for the appellant submits that he has received a copy of objection through another set of learned counsel. He prays for it is granted. Time to take instructions. List for hearing on when?
Lordship fix it after 19th April.
List for hearing in the week commencing 29/4/2024.
Pleasure.
Already completed. Then this principle will come 300 because then there is no escape. There was a trial and there's something more. Come to 461 again. You'll have to show us that this
461 of CRPC.
CRPC. You'll have to show that this was an irregularity with vitiated proceedings.
Vitiated proceeding. Irregularities which vitiate proceeding. Yes.
So except for that,
Ah.
no other defect or error will vitiate a sentence.
was illustrative,
No, this is not illustrative.
exhaustive.
Yes.
This is a case where the judge has himself conducted the case, which is totally against 226.
465 is that residuary procedure.
Subject to the provision, no finding, sentence, or order passed by court of competent jurisdiction shall be reversed or altered by court of appeal. Confirmation or revision on account of any error, omission, or irregularity in complaint, warrant, proclamation under the board or any error, unless in the opinion of the court of failure of justice. has been
No. Here, this here you will see in the last part of 465(1), judgment or other proceeding or during trial or in any inquiry or in any proceeding under this code. So you see, the trial itself is a proceeding under this code. So any irregularity on account of that under 465 is not reversible.
But failure of, unless in the opinion of court, failure of justice has been occasioned there. Again, a rider.
Because you see, it is not the case that the respondent has come in appeal, saying that this has vitiated the proceeding. So in an appeal by the convict, perhaps you can't put him into a worse situation than he's already in. But let us discuss, we have a question for you. Now you see, come to 465. Last two lines. For the irregularity in sanction for the prosecution, unless in the opinion of that court, a failure of justice has in fact been occasioned thereby. So can we not say that since the APP was not there, perhaps you were not appropriately tried and therefore it has occasioned failure of justice for you?
On judgment, Hardeep Prajapati versus State of UP, 2007, Lordship. There it has stated this the cause of substantial justice should not be defeated on some technicalities, Lordship. There is a suspend on that.
No, that's what our question is. You see, we have posed that question to him. Now, you have to show us the same question is for you to answer. The question is suffering of injustice to whom? This is applicable to whom?
You have to balance the interest between the informant and the accused. Cannot always take the side of the accused. And it's not a very old case. To 2020, the entire incident happened.
It's not on the question of delay. It's the question of section 300. How do you overcome that? Once it has been tried,
Once has happened.
because every case you will find,
Ah.
which I showed you earlier also, where what happened was if there's a discharge of the accused impropriety and therefore that's not said to be a completion of trial. And therefore, when somebody is discharged at the stage of for explanation of charges, that time, if it failures occasion, if justice has failed, then the court can send it back for trial because that time trial has not taken place. But after trial, are we not bound by 481 and interpretation of 465, which I just posed the question?
300 also, there is one term without jurisdiction, with jurisdiction. Now we can say, in our case, it is totally without jurisdiction.
No,
We
it was
cannot try.
jurisdiction. He had the jurisdiction. It is a procedural impropriety. You can't say that the POCSO judge did not have the jurisdiction.
Had the jurisdiction, but to try, he did not have.
No, he had the jurisdiction to try.
An evidence check, Lordship.
165, the judge. can-
165 is the power of the court to ask questions. It merely says, you see in the proviso you will find, it only says that the court will not, what do you call, how did I forget this sentence? It says, he shall not dispense with the proof of the document. That is the only thing under the Evidence Act. Proviso, please see the proviso 165. Nor shall he dispense with the primary evidence of any document. Only last part of 165.
Nor shall be dispensed with everything. 165, it's okay. He can put questions anything he wants, but he cannot take the role of a prosecutor. 311 also empowers the court to put questions,
Yes,
additional evidence.
no, but 311 is in a context which is a bit different.
Ah, different.
311.
The court shall summon and examine and recall and re-examine such person. if
Yes.
Evidence appears to be essential to the just decision of the additional evidence.
Additional evidence can be read because here schedule 1 was called, schedule 2 was called, so therefore court can do it under 311. No dispute with that. Now we are on the absence of PPE, whether it can be said to be a proceedings without jurisdiction. We can't hold that.
That is what I thought, absence of PP without jurisdiction he had. He didn't have the jurisdiction to take the role of a PP. That is what I said, that,
He taking that.
300, the only decision is Nanjappa. I think this will, because here also, the people were acquitted, it's an appeal, and then he was tried. Lordship will see, he was tried. First paragraph. Appeal arises from the judgment so and so passed by Karnataka, whereby the High Court, while reversing an order of acquittal passed by the trial court, convicted the appellant under 7 and 13 and 13(2) of the PC Act and sentenced him to undergo so and so. And in that context, because there was no valid sanction,
Oh, no. We don't have, we can't say that there was a conclusion of trial. Here is a case where the Supreme Court is saying that instead of acquitting him, he could have been discharged.
discharged him.
So question of discharge will only come at the time of explanation of charges. After trial, there can't be a discharge. It has to be acquittal.
After trial, no discharge.
Therefore, you see, in this case, the decision you are referring to, Nanjappa,
Yes.
it says that the here in determining whether any what do you call this
The case is not against framing of charge.
Because this is paragraph 17. Paragraph 17.
Lordship.
And the case in hand discussed this in a previous judgment of Brajnath Prasad Tripathi. And then in our opinion, the only error which the trial court in our opinion committed was that having this sanction invalid, it should have discharged the accused rather than ordering an acquittal.
But Lordship will see the last paragraph, whether we should permit launching of a fresh prosecution. That was also written. The next question then is whether we should, while allowing this appeal, set aside the order passed by the High Court and permit launching of a fresh prosecution against the appellant at this distant point of time. That means it is allowed, but then in the facts of the case, it was not done so.
That's why we showed you this once, 465. And therefore this question to Mr. Ahmed, yes, what do you say? Section 465.
465, finding or sentence when reversible by reason of error, omission, or irregularity, subject to the provisions herein before, contain no finding, sentence, or order passed by a court of competent jurisdiction shall be reversed or altered by a court of appeal, confirmation, or revision on account of any error, omission, or irregularity in the complaint, summons, warrant, proclamation order, a judgment, or other proceedings before or during trial, or in any inquiry or other proceeding under this code, or any errors or irregularity in any sanction for the prosecution, unless in the opinion of this of that court, a failure of justice has in fact been occasioned thereby. So now in my case, Lordship, that failure of justice is there. I have placed before Lordship that CW1, who was the daughter-in-law of the informant, who appeared as Lordship, as daughter of the informant, who accompanied the victim. So there was some manipulation in the evidence of the witnesses right there. Because the prosecution.
No, that's not the question, because that is the appreciation of evidence. The question posed to you is that when we say that in the absence of the public prosecutor, you were tried, can it not be construed to be a failure on justice to you because you are not competently prosecuted? So if you,
The court is acting as the prosecutor himself. So don't you feel that there is some failure of justice? I mean, on that plea, maybe we can set aside. You know, if you read
because
465.
we are speaking of setting aside and remanding it back.
That remanding back that, Lordship, I have my submission. Because the evidences are already recorded. The witnesses knows.
No.
The witnesses knows on what ground that accused can be convicted. So they are aware, they were now completely, they have the knowledge on that aspect. So retrial will prejudice the accused persons.
In fact, the absence of PP, I can see some reason here, it's because of the COVID. Because till 21, he was present. He in fact had prayed for further investigation in the matter. After that, he,
There may be valid reasons for the APP
there-
not to be there. It could have been through video conferencing, but whatever. But for the court to take up, you see, what happens is that I'm just thinking aloud. We are not speaking for the bench. I'm just thinking aloud. Uh, the same judge explains charge and then takes up the trial. Not only that part, when he finds that the evidence is lacking, so he calls up CW 1 and 2. Prosecution never presented them. So he calls CW 1 and CW 2 and then takes up. Therefore, you see, he participates in the what you call, not only he exercises power under 311 here to call those PWs, but since he has explained the charges, he is now taking the prosecution in a particular direction.
that will be again biased, but that will justice to the accused.
Because you see, the power of the court to ask questions is unfettered.
Yes.
So if I am taking up trial and then I find, just like we call for the case diary or for the documents from you and then inspect it and then find that why this has not been done. In the earlier case, we also issued a notice for the forensics to give us a comparative examination report. So that is when we are dispassionately adjudicating an appeal. Certain things are pointed out and we take steps. So the question of either prejudice or a predetermined, premeditated mind is not there. Is absent. This is the course of argument that something has come out, and in the previous orders you have seen, we have asked for the report of the serological examination report, FSL report. So that is otherwise permissible. But here to set it
No,
aside and
yes.
then
Whatever reason,
send for a,
this conducting the trial with by the court is totally illegal. That a judge cannot be a prosecutor. 226 is very clear, it has to be by the prosecutor. I'm just saying there are some
we
reasons why.
can, what do you call this, order of rejection can be tried and tested.
In the Supreme Court.
I won't say where, but it's always,
Always open for.
it's,
One does not also just 2017 12 SEC.
just. 2017 12 SSC
699.
699.
Around that point that retrial should not be directed in a routine manner. Means exceptional circumstance that has to be there.
Yes, there's no quarrel with the. That
No,
is
that's not required. We are also not doing it.
Which I have placed before
We
Lordship,
we are also not doing it mechanically. We have put it up at 2 o'clock on hearing on this.
No,
So
actually, my fairly submission, I was not, my submission was not that you Lordship passed in a mechanical way. But on the point that evidences were already recorded, which I have submitted before Lordship just a few minutes back, and that portion is there in the judgment. And that because of that, Lordship, I have placed this citation. before
which
Lordship.
one?
Yeah, right.
2017 12.
Yes.
Let us see that.
99.
Yes, which paragraph?
Just,
Here again, same thing. That reference which I was making, he has shown this judgment. In this judgment, it is recorded. This court is referring to that nursing case of 2015, 1 SCC 496, and said that in our view, the High Court has not properly appreciated nursing's case where the court has laid down that the appellate court can order for fresh trial from the stage of examination under section 313. That also doesn't help us
Help us, yes.
because it will be retrial from the stage of explanation of charges. But then all the evidences are over, the lapses are apparent. The points which are in favor of the accused or in the favor of the complainant are all exposed. So gaps would be filled up. This is 313 when I was referring, I was not aware of this particular citation, but now this nursing has again come.
Nursing is on 313 state.
No, I have not read that. This citation is it's mentioned. 2015 1 SCC 496.
Then we have been placing a lot, I mean, how 313 has to be done. Basically not. At what point it get prejudiced, at what point it does not. In nursing's case, actually the FSL report was not placed before the witness, before the accused. Nothing to get? In fact, once the public prosecutor appeared before the judgment on 18/8/22 to reply to section 232. 232 is not a case of acquittal. Again, after that,
So which date?
18/8/22. After that, it was fixed for argument, after 313. Yes. Only
313.
one day.
313,
After
we have the
three-
paper book. We have the paper book.
No, no, this is from the record. The order sheets. Before argument, after 313.
So against the APP doesn't appear. Even after that, it's a
It's not-
solitary.
Not in the arguments, nothing. The fact remains the trial is vitiated. That fact will remain. His appearing one day will not make any difference. The fact remains. But whether it should result in acquittal or remand, that is the question.
And yes, Mr. Hussain,
Remand the matter by acquitting him, then I have no any objection, but releasing him. But if your lordship desire to acquit him, then I have
no, what we will do is our prerogative. Don't take that freedom away. You'll have to, you have to make a choice. But assuming both, we have powers to do both. So in both circumstances, what is your submission?
my submission, remand the matter for fresh trial. Because
Then the
sometimes
same questions to you, that if the trial according to you, whether or not it has vitiated under the circumstances present before us.
This regard, my lord, I have to gone through some judgment, my lord, because I have not gone through the judgment. That is why, my lord.
No, judgments are not there. Don't worry about it. Judgments are not there. Because I have tried my best.
Even I tried it. I didn't go anywhere. I was sitting. I tried to find.
Because if I,
Kerala, I could get.
because if I miss it, it will be very hard for you to find it. Huh?
Since last 2 days also I was searching on this as well.
It's not there because if I'm making a search and if I'm getting to find it, I would doubt others would find it.
On the fault of the, my lord, presiding officer, my lord, the victim may not be prejudiced or deprived from justice. My
No, you see that prejudice will not come because of the fact that in POXO cases, although the because you did not exercise the power to assess the public prosecutor at any point of time. Therefore, you are conveniently out of trial. It's not the case that you are prosecuting and then
I have gone through on orders, my lord. The PP is not interested to issue the summons. That is why the court himself issued summon through police station, my lord. This on record, my lord. PP may not be appeared, my lord, due to, my lord, COVID.
no, for that you see that could have been one part, but this COVID was there up to what time? February. By the time the trial was already over. You just look at the order sheet again. That heard. Anything more? Heard Mr. A. Ahmed, counsel for the appellant. Also heard Ms. S. Jahan under APP and Mr. D. Hussain Leonard. M. Hussain, I'm sorry. Mr. M. Hussain Leonard, counsel for respondent number 2. Next paragraph. By filing this appeal, under section 374 within bracket 2 CRPC, comma, the appellant Niru Sikdar alias Nur Sikandar has assailed the judgment and order dated 5/12/2022 as well as sentence passed on 3/1/2023 in this was passed by the Special Judge Chirang in special case number 4 of 2020, thereby convicting the appellant under section for committing offense under section 376 within bracket 3 IPC read with section 4 of the POXO Act and sentencing him under section 376(3) IPC to undergo rigorous imprisonment for 12 to 20 years and also to pay a fine of rupees 40,000 in default to undergo further rigorous imprisonment for another 3 months. Page 2. In order to protect the identity of the victim, comma, in this order, the informant, who is the father of the victim and examined as PW1, is referred to as within bracket, sorry, inverted commas, X, and the minor victim was then 15 years old, is hereinafter referred to as Y. Full stop. Next paragraph. On 5/5/2020, an Ejhar was lodged by X alleging that the appellant had committed penetrative sexual assault on his 15-year-old minor daughter in a paddy field on 5/1/2020 at about 5 p.m. Accordingly, Basugam PS case number 2 of 2020 under section 376 within 76 IPC read with section 4 of the POXO Act, 2012 was registered. Full stop. On completion of investigation, the IOH submitted charge sheet under section 376 IPC read with section 4 of the POXO Act, 2012 against the appellant. Full stop. by order dated. LCR 2. Fourteen three 2022, charges were explained. Charges were framed against the appellant under section 376 within bracket 3 IPC, read with section 4 of the POXO Act. Which was read over and explained to him, and the appellant pleaded not guilty, and therefore the case was tried. Full stop. During the trial, X within bracket informant was examined as PW1, Y, the victim was examined as PW2, Dr. Mrs. Dipali Borduloi Manta, MANTA, the medical officer who had examined the victim and submitted her medical report, was examined as PW3, and Hare Krishna Kalita, the IO, was examined as PW4. Full stop. The court also examined the Caesar witness within bracket, sorry, inverted commas A within bracket, name withheld, of birth certificate of the victim and the younger sister of the victim, referred as inverted commas B within bracket, name withheld, was examined as CW2. No, just say who had accompanied the victim to the place of occurrence, was examined as CW2. Most of the following exhibits were proved Page 38. I put a flag. So on conclusion of the examination of prosecution witnesses, comma, the incriminating evidence which appeared which appeared against the appellant was put to the appellant. Given charge explained by order dated 14/3/2022. Then this P13 examination was done on 18/8/2022. And he was examined under section 313 CRPC. Poster. The next part, that on the basis of the evidence on record, comma, and the arguments made in the case, comma, the Ghana trial court had formulated the following questions for determination in the case. Page 20, paragraph 5, 1, 2. Next paragraph. The informant was examined as PW1. The informant X was examined as PW1. Had exhibited the Ejahar within bracket PW1 and his signature thereon. And the printed form of the FIR was exhibited as exhibit P2, P1, P2. He had deposed to the effect, in his examination chief, he had stated that the incident occurred at 5 p.m., between 5 p.m. to 5:30 p.m., about half a kilometer away from his residence in a field, which was used as grazing field. And when he came to his residence, he found that his daughter was already there and was crying. And she informed that the appellant had gagged her mouth with the help of a cloth, dragged her to a bush and committed penetrative sexual assault on her. Stop. Accordingly, he went to the police, Basugam police station with his daughter, and the police recorded his statement as well as statement of his daughter. And then someone drafted the Ejahar. Within bracket exhibit P1. Stop. He also stated that the victim was brought to Kajalgaon Civil Hospital, but in the absence of the doctor, a medical examination could not be done. And thereafter, the victim was taken back to the Basegam police station and then thereafter to his residence. Stop. He has stated that after a gap of 1 day, the victim was again brought to the Kajalgaon Civil Hospital and a medical examination was done. And he has exhibited the medical examination report within bracket exhibit 3 and his signature thereon. It also stated that the victim's birth certificate was seized by the police and his signature was taken on a piece of paper, which was exhibit P4. And his signature was also exhibited. It stated that the seizure witness within bracket inverted comma A had accompanied her when he had gone to the police station, and she had signed the seizure list within bracket exhibit 4 of seizure of the birth certificate of of his daughter. He had identified the appellant at the dock. So in his cross-examination, he could not say the date on which the case is instituted or the person who had, and also could not identify the scribe of the Ejhar. And he had stated that he had taken his daughter to the police station at about 7 p.m. No, no, not required. This part is not required. It says 7 p.m. 7 p.m. And that about after 2 or 3 days, at around 2:30 to 3 p.m., or the police had visited his residence. And he had stated that his victim daughter what would this mean? He had also disclosed the name of younger sister of the victim as inward commas B within bracket name withheld, who was born in the year 2009. No, sorry, no, not here, not here. This will be before cross-examination. This slide, after cross-examination. He has also admitted that earlier he had instituted a case against the appellant and his brother, which has resulted in acquittal after compromise. He had denied that his victim daughter was married to Quran Ali, Kuran Ali, son of Isap, ISAP, Isap Ali. And he denied the assertion that the case was filed with false allegations, as he was acquitted in an earlier case. And he denied that no incident took place against his daughter. Next para. The victim was examined as PW2. Full stop. In her examination in chief, she has stated that in the month of January 2020, at about 5:30 to 6 p.m., she had gone to bring back her cows, which were left in a field near the house for grazing. Her younger sister, within bracket, inverted commas, B, had accompanied her. It had become dark at the time of the incident, and there was a drizzle. And the appellant came, gagged her mouth with a cloth, dragged her to nearby bushes, and after removing all her clothes, he raped her. She has also stated that her younger sister was in the field where cows were grazing. It was stated that the appellant had detained her for about 1 hour, and after much struggle, she could free herself and came back to her place, to her residence. And by the time, her younger sister had already gone home. She narrated the incident to her father, who took her to a police station to institute the case. She had identified the appellant on the dock. First one. She stated that on the that she was medically examined at Kajalgaon Civil Hospital. And she had narrated the incident to the doctor. And on the next day, she was brought to court. And she had exhibited a document which is marked as Exhibit E5. He stated that she was called in court and she was asked to put questions, to put signatures on the document. She did not remember if she was asked anything. And she also does not remember if the person who had taken her signature was a male or female. She says that she had said that her birth certificate, that in the student registration certificate, her date of birth was 12/1/2005. Student registration card within bracket Exhibit 6, P6. In a cross-examination, she stated that before the incident leading to the said case, there was a court case between her father and the appellant. She had denied this assertion that because of the said case, the two families were not in talking terms. But she admitted that they were not in visiting terms. She has denied that she had not stated to the IO about the IO that the incident had taken place in the field near the house of the appellant. He also denied that she did not say before the investigating officer that her younger sister, within bracket B, had also gone to the grazing field, or that it had become dark and that there was a drizzle, or that the appellant had gagged her mouth and her mouth with a cloth and gagged her to nearby bushes and or that her sister B was in the field where cows were grazing, or that the appellant had detained her for about 1 hour. That she could free herself after much struggle and came back to her residence, or that her younger sister had already gone home when he reached there and father was in the residence. First of all, she has admitted that she had entered into a marriage agreement with Quran Ali, and the name of his father was Isop, ISOP, Asop Ali. But she denied staying with Quran Ali. First of all, she has stated that that A within bracket CW1, sorry, inverted comma, CW1 was her elder brother's wife. And she denied that she was not raped by the appellant. And that the case was filed because of family dispute and grudge. Was falsely filed. Next paragraph. The subdivisional medical and health officer in JSB Hospital subdivisional medical officer at JSB Hospital, Chirang at Kazilgaon was examined in PW3. He has stated that on 6/1/2020, she was working as SDM and HO in GSB Civil Hospital, Chirang at Kazilgaon. And at 11:30 a.m., on police requisition and pursuant to Basugam PS GD entry number 139 of 5/1/2020, he had medically examined the victim within bracket Y, inward commas Y, 15 years. Were identified by the woman homeguard and the father of the victim, and with consent of the father of the victim, she had conducted the medico-legal examination. And she had also taken her the signature of the father in the medical report. Full stop. Next paragraph, he had stated that, sorry, this PW3 had stated in his examination in chief that the victim had given a history of kidnapping on 5/1/2020 at 5 p.m. History of sexual assault, and returned back to her home on 6/1/2020. She had found, on examination of the victim, she had found superficial abrasion present in both sides of breast, and tender pain was present. So, however, no injury was found on her body or her private parts. So, hymen was absent. And on examination, there was pain in the vagina, but there was no tear or bleeding. And the vaginal smear was taken, but gave negative result of spermatozoa. SPERMATOZOA. And there was no evidence of struggle and tears, or evidence of stains like blood, saliva, semen, etc. We had opined that the age of the victim girl was between 15 to 17 years. And it could not be ascertained whether the victim had been subjected to sexual assault or not. She had exhibited the medical report within bracket exhibit E3 comma, her signature as well as signature of the father of the victim. Full stop. She has also exhibited the radiological examination X-rays within bracket exhibit P5. But this is wrong. Finding at page 18. Sorry, the examination in chief at page 18 appears to be incorrect from the page 38. Here he says exhibit P5 is the report of radiological examination. Page 38 says exhibit 5 is statement of victim. But we have to write whatever is available.
In the paper book, Lordship, page 38.
In the paper book, page 18, second last paragraph, exhibit P5 by PW3 is the report of radiological examination, correct?
Yes.
Now come to page 38. Page 38, exhibit 5 is statement of victim. PW7 is the radiological examination report.
Judgment is,
No, 38.
yes, my paper book, Lordship, is judgment.
Oh, no, not paper book. I'm reading from memo appeal. In this judgment, you will find in the paper book, you will find this is page the lecture, page 58, not 38. It is 58. You've seen that? Exhibit 5 is statement,
Yes,
not that.
statement of the big.
Hmm.
Uh,
She has exhibited the medical examination report as exhibit P3
Yes,
and a signature thereon. First of, however, comma, it may be mentioned that as per the schedule appended to the impugned judgment, comma, the radiological report of the victim is exhibit P7 and exhibit P5 is the statement of victim recorded under section 164 CRPC. And exhibit P5 under script 2, sorry, 1 and P5 under script 2 are the X-ray plates of the radiological examination. She had exhibited the pregnancy test report and the vaginal swab test report as exhibit P6. Full stop. In her cross-section, she was only asked, she had only stated that the victim was produced before her on 6/1/2020 and she had examined her. Stop. The IO was examined as PW, the IO was examined as PW4. It stated that on 5/1/2020, he was working as second officer in charge of Basigam Police Station. And on receipt of the Azhar from the PW1, the then officer in charge of Basigam Police Station had entrusted him with the investigation of the case. First off, he had exhibit P1 within bracket numerical 2 as signature with endorsement of exhibit P1. First off, it stated that the PW1 is a signature with endorsement on exhibit P1, first information which I know as a signature of is exhibit the signature of the officer in charge, Basigam Police Station. This is Harin Chandra Dhaka. Acha. As well as the signature there, signature of the officer in charge. There are. In course of investigation, he had examined the witnesses and interrogated the appellant. And thereafter, the victim was forwarded. He had recorded the statement of he was. No, examined the accused and victim, appellant and victim. And thereafter, the appellant was forwarded. And I'm sorry, thereafter the victim was forwarded to court for recording for getting a statement recorded under section 164 CRPC. Within bracket exhibit P6. आपको bracket दी बोलेगा bracket. As per schedule appended to the judgment, P6 is referred as student registration card. And that the And that the statement of the victim is marked as, is shown in the schedule to the judgment as exhibit P5. He had visited the place of occurrence and prepared a sketch map within bracket exhibit P7. It may be mentioned here that exhibit P7 is the radiological report of the victim in the schedule appended to the judgment. And that the sketch map was marked as exhibit P10 in in the schedule in the schedule appended to the judgment. Stop. He recorded the statement of witnesses and seized the birth certificate of the victim via exhibit via seizure list within bracket exhibit P4. He had seized the birth certificate of the victim via exhibit P4 and also exhibited the said birth certificate within bracket material exhibit 1. He collected the medical legal injury report of the victim, completed the investigation, and charge sheet was submitted. He had marked the charge sheet as exhibit P8. So it may be stated that as per schedule appended to the judgment, exhibit P8 is the report of pregnancy and swab test. So he had exhibited the sketch map within bracket exhibit P7. First off, it is once again stated that exhibit P7 as per schedule to the judgment is radiological report of the victim. Something is wrong in your prosecution. In the cross-examination, he had deposed his examination in chief. Sorry, in his cross-examination. That the victim was forwarded for medical legal examination and for recording a statement under section 164 CRPC on 6/1/2020. So the is explained the location of, no, it's not location. He had given the description of the contents of the sketch map. Within the exhibit P7. And it is again reiterated that as per schedule to the judgment, exhibit P7 is the radiological examination report of the victim. Location of various places marked in the sketch map. It will. He had stated that he had not verified the authenticity of contents of birth certificate within bracket material exhibit 1. And he had also stated that in her statement, the victim had not stated to him that the incident leading to this case had taken place in a field near the house of the appellant, or that the younger sister of the victim had gone to the grazing field or that it had become dark or dragged to a field, cows were grazing, all that part. Page 23, para 12. The seizure witness was examined as TW1 by the London Trial Court. She had identified the appellant whose residence was 3 minutes walk away from her residence. She has stated that the incident occurred She stated that the incident leading to the case had taken place about 2.5 years ago, 2.5 years back at around 5 p.m. in a field which is half a kilometer away from the residence. The victim had gone there to bring back the cows left for grazing. She had not accompanied her there, but she was accompanied by her younger sister, within bracket, sorry, inverted comma B. She stated that around 5 p.m. when the victim came back to her residence, she told them that the appellant had grabbed her hands and at that time the father was present in the house, and then all of them had gone to the police station. She has stated that the police had recorded her statement and took her signature on a piece of paper, and she had stated that exhibit P5 was the document where she had put her signature. For P4, full stop. He did not remember anything, if anything was written in the said exhibit P4 at that time. She did not know why her signature was taken. And she only knew that her signature was taken to make her a witness. She had stated that the police had taken birth certificate of the victim from her father in her presence. And that B, in the bracket, younger sister of the victim, bracket goes, had returned back home before the victim. Stop. In a cross-examination, it admitted that she was the wife of one Rabiul Hussain, Rabiul Hussain. And that the informant was not her father, but she was his neighbor. And that he had 2 sons and 4 daughters, and she was not one of them. She stated that the informant happens to be the husband of her father's sister. He stated that the informant had 2 more brothers, and her husband was the son of the informant. And she also disclosed the name of another brother of her husband. She had also admitted in her cross-examination that the victim had entered into an agreement of marriage with one Quran Ali. And she stayed in the house of said Quran Ali sometimes, and sometimes in the house of her father. It also stated that she was not, there is no field near her residence. And that the police had recorded her statement at around 8 p.m. at the police station. And thereafter she came back to her residence at about 10 p.m. along with her father-in-law, the informant. And she was residing in the house of the informant. Full stop. She had denied that she had impersonated as daughter of the informant. And she has also admitted that it was the fact that he was not that he was not that the daughter of the informant. No, sorry, neighbor of the informant. Neighbor of the informant. Next para. At this stage, the learned counsel for the appellant has submitted that on the said on such evidence of CW1 being recorded, as she had misled the court, the learned trial court by an order dated 23/5/2022, was held to have committed an offense under section 195 IPC. And accordingly, a direction was issued for recording a formal complaint before the Court of Chief Judicial Magistrate, Chirang Kajulgaon. And accordingly, the said CW1 namely, and therefore this A, comma, they said CW1 was taken into custody for production before the learned Chief Judicial Magistrate, Chirang. On a perusal of the PCR, comma, they said order is found on record. Next paragraph. The younger sister of the victim, inverted commas B, was examined as CW2. Most of the court asked certain questions to her to as child witness, and on finding that he was a competent witness, again there is another mistake. 13 years. So, nonetheless, comma, although the learned trial court recorded that the age of the CW2 was 13 years, comma, oath was not administered to her. Full stop. So therefore, as oath was not administered to the 13-year-old CW2, comma, we have not referred to the examination in chief of this said CW2. However, in her cross-examination, she had no, her evidence is not referred to. Next, the victim was examined under section 313 CRPC by putting before him the incriminating materials which are available against him, to which the appellant took a plea of denial. Stating that he has been falsely implicated. The learned trial court on appreciation of the evidence on record. Accepted the evidence of the victim within bracket PW 2. And arrived at a finding that and found the evidence trustworthy. And taking note of the evidence of PW3, i.e. the medical officer, who had found superficial abrasion present in both sides of the breast of the victim with tender pain present, comma, told that the evidence was suggestive of sexual assault, notwithstanding the opinion given by the medical expert. It was also held that the appellant failed to rebut the mandatory presumption raised under Section 29 of the POCSO Act. And therefore, holding that the absence of hymen may be due to various reasons. Held that the appellant had committed penetrative sexual assault on the victim, and therefore he was held guilty of having committed offense under Section 376 within bracket 3 and Section 4 of the POCSO Act. The evidence of CW1 was discarded by holding that he was merely a hearsay witness. And it was also held that the testimony of PW4 did not shed any light on the incident. Resultantly, the appellant was sentenced, was heard on sentence, and he was sentenced to undergo rigorous imprisonment for a period of 20 years and to pay a fine of rupees 40,000, which, if recovered, was ordered to be paid to the victim, with default stipulation of further undergoing rigorous imprisonment for 3 years, 3 months. And the victim was ordered to be paid compensation from the under the victim compensation scheme of the state government. Next paragraph. On being pointed out by the learned counsel for the appellant, we have observed that the that on and from 14/3/2022, the date when the charges were framed against the appellant by the learned trial court, till the stage of examination of the IU appeared on one occasion. (26) till the till the examination of all witnesses examination of witnesses till the examination of witnesses and closure of the evidence of the prosecution on 26/7/2022. What is the date you said? 26/7/22. Oh, no, then you say, no, just a moment. 31/5/2022. Yes. No, that's over. He was present on one day when he had argued on PP's presence was there one day. After 313 or before 313?
Yeah, probably in the month of August or.
No, that was closed. No, on one day he was present. APP said.
Yes. I can show.
The APP was present on one day. Public prosecutor not appeared, producer not appeared. Not appeared. Not appeared. Not appeared. And even thereafter, till the pronouncement of judgment, or the presence of the public prosecutor is not there. Full stop. The charges were framed by order dated 14/3/2022, when the APP was not there. The PW1 was examined on 5/5/2022. PW2 was examined. Oh, no, don't say it like that. You say witnesses whose name appeared at charge sheet, in the charge sheet as PW1 was examined on 5/5/2022. The victim was examined as PW2 on 23/5/2022, comma. Witness at serial number 6 of the charge sheet was examined at PW3 on 31/5/2022. Comma, CW2 was examined on 22/6/2022, comma, IO was examined as PW4 on 26/7/2022. The appellant was examined under section 313 CRPC on 18/8/2022. And the final argument was heard on 7/11/2022. Full stop. On all these dates, the learned APP was absent. Full stop. Therefore, comma, it is seen that the learned special judge within bracket POXO, Director Chirang, had not only taken over the role of public prosecutor, but he also adjudicated the case. Full stop. The which did you said that he said that hearsay evidence not required? Where is that? 31 5. It is also, it also appears from the order dated 31/5/2022 that the learned trial court had issued directions to the officer in charge of Basimo Police Station to ensure presence of witnesses, and also and by perusal of the case diary, or the court, the learned trial court was of the opinion that witnesses at serial number 3, 4, and 5 of the charge sheet were hearsay witnesses, and therefore their examination was not considered necessary. So this shows that that during the trial process, comma, the learned trial court had the learned special judge had assumed the role of a public prosecutor. Full stop. Next para, in the considered opinion of the court, comma, the trial is found to be vitiated because of absence of, because in the absence of the public prosecutor, comma, the prosecution evidence was opened and concluded by the learned special judge POXO. Next para. In order, on a query put by the court to the learned public, to the learned additional public prosecutor, as well as to the learned counsel for the respondent number 2, they had submitted that the trial cannot be said to be vitiated on account of lack of public prosecutor. And in the event, this court was of the opinion that the trial was wrongly conducted, this would be, in view of the nature of offense alleged to be committed by the appellant, this was a fit case for retrial of the case from the stage of explanation of charges. However, in response, the learned counsel for the appellant has referred to the provisions of section 300 CRPC. And it is submitted that as the applicant has already undergone a trial, a retrial cannot be ordered. In support of his submissions, the learned counsel for the appellant has cited the case of Adan, ADAN, HAJI, JAMA, JAMA, and others versus the King. EIR 1948, PC 63. Equivalent to Manu, MANU, oblique PR, oblique 0069, oblique 1947. Decided by the Privy Council on 9/12/1947. As well as the to I was submitted that the breach, the absence of public prosecutor necessarily involved a breach of section 226 of the Criminal Justice Ordinance, 1926 of the Somaliland, SOMALILAND. No, spelling SOMALILAND. Protectorate, PROTECTORATE. Which required that the prosecutor shall open the case. Here, what is the provision? 226. Full stop. In section 226 of the said ordinance is quoted below. Page 2. Let's not. Full stop. The relevant provision in the Criminal Procedure Code, 1973, which is section 226 CRPC, is quoted below. Full stop. The next paragraph, the learned counsel for the appellant has also cited a copy of, has produced a copy of the order passed by the division bench of this court in WPC 4/2006. Proceed that. That whenever that it was circulated to all sessions judges and chief judicial magistrates in the state, that in the event public prosecutors or additional public prosecutors were not appointed for conducting of criminal cases, comma, the matter should be taken up with the district magistrate for appointment of the public prosecutors and assistant public prosecutors. Full stop. Accordingly, it is submitted that the learned trial court could not have opened the case on behalf of the prosecution and proceed to determine which evidences would be whose evidence would be recorded, and then take a decision to call witnesses at court witnesses and thereby adorn A.D. Warren, the cloak of a prosecutor. First, next para, in the said context, we may refer to the provisions of section 461 CRPC, which prescribes the irregularities which vitiates proceedings. And we do not find that the present situation is one which is covered by the said provision. Full stop. However, from the provisions of section 330 CRPC, it is noted that sorry, it is 330. What was it provision? 3? That no second trial is 300. 300. 300 CRPC that it is provided that a person once convicted or acquitted should not be tried for the same offense. Full stop. They said provisions of section 300 CRPC is quoted below. Full stop. Next paragraph. From the explanation appended to section 300 CRPC, it is noted that the dismissal of a complaint or discharge of the accused is an exception to an acquittal for the purpose of this section. Full stop. In the present case in hand, the trial was the appellant has suffered a trial and he was awarded with a punishment on being convicted. Full stop. Under such circumstances, we do not. The court is of the considered under such circumstances, the court is of the considered opinion that the case of the appellant would squarely fall within the scope and ambit of section 300 CRPC, and it would be more injustice to the appellant to be sent for a retrial. Full stop. Argument was advanced by the learned APP based on the provision of section 465 CRPC. Project that the absence of APP or public prosecutor or APP in the court of Special Judge Poksu Chirang led to the court examining the witness in view of the time limits prescribed under the POCSO Act for conclusion of trial. And therefore, at best, this could be a case where there, where due to failure of justice, the finding and sentence can be set aside and the matter be sent for retrial. So in the said context, the court is of the considered opinion that in this appeal against conviction, the appellant has not taken a ground that that a failure of justice had occasioned. The specific argument of the specific submission of the learned counsel for the appellant was that as the trial court took over the prosecution, illegality was committed. Full stop. In this regard, we find that this is not a case where it can be held that there was a failure of justice. Full stop. The provision of section 465 CRPC is quoted below. Next paragraph, from the provision of section 465 CRPC, I find that no finding, sentence or order is liable to be reversed or altered in appeal on account of any error or irregularity in the trial. Full stop. It is not the case of the appellant that the absence of public prosecutor during trial has occasioned failure for justice so far as the appellant is concerned. Full stop. Therefore, we are inclined to hold that this is not a case where there was a failure of justice, but this was a case where the learned trial court had donned DAWNED, donned the cloak of public prosecutor, and therefore became the judge and the prosecutor. Stop. Next, accordingly, the court is of the considered opinion that in this case, as the learned trial court is found to have acted as a judge and prosecutor in absence of the additional public prosecutor, the judgment impugned in this appeal is found to be vitiated. Just from the entire procedure of trial is not found to be in consonance with the scheme provided under this Criminal Procedure Code. Has the appellant in this case deserves a acquittal. as the impugned judgment and order dated so and so. As by granted so and so is not found to be sustainable on facts and in law. Therefore, the court has no hesitation in setting aside the said judgment. By next para, as the merit of the evidence has not been gone into. As we find that the trial, since its inception, from the stage of framing of charges, was vitiated. According to evidence, and the resultant judgment is vitiated, as the learned trial court had donned the role of a prosecutor, had performed the role of a prosecutor. The so and so judgment is set aside. And the appellant is acquitted due to vitiation of the judgment of the learned trial court. Next para, we clarify that we have not appreciated the evidence of the witnesses during trial. Therefore, the acquittal of the appellant is on technical ground and not on disproving of the offense for which he was charged. But in some substance, we have said that but we may have to reframe certain paragraphs. This will be released after a few days.
It's very peculiar circumstance.
Because we'll have to introspect. So, this is the order passed. But you write the formal order. The arguments are concerns Mr. A. Ahmed for the appellate. This is John AP for the state, along with Ms. S.S. Bora, learned AP, and Mr. M. M. Hussain, counsel for the respondent to have been heard, judgment reserved. Because there will be difficulty if we don't upload it within time. There will be some questions asked, and my sister will be leaving tomorrow morning, so we'll have no time to discuss tomorrow at least. There's something final points we'll have to take it up. After 75, well, this will be the first case in the country, probably. So let us fine tune it. We don't want errors to be there in the order. It will be a subject of large scrutiny.